Good evening, everyone, and welcome to Good Governance GGY's Roundtable discussion. With the absence of our moderator, Chaminda, who is traveling overseas, my name is Tassie and I will play host for today. A very warm welcome to our special guest for this evening, a well-known name associated with critical issues facing our country, Dr. Gehan Gunatilleke. I wish to also introduce the other GGY regulars with me today. This is Auntie Maubrey, Chris, Dushi and Chirantha, and in the background there we have Annie, we have Angela, we have Damaris, and of course CK in our background who does all of our tech work for us. So we'd like to welcome you all to day 265 of GGY. GGY, as you know, is a neighborhood vigil that happens every Sunday at 5 p.m. down Timigasai Road, opposite Health Guard Pharmacy. We have been standing at our street corner since April 2022, where our demands have been for better governance, accountability and transparency, an end to corruption and nepotism, and equal application of the law. And we believe that these could only be accomplished with a system change and a change in political culture. So thank you so much, Dr. Gunatilleke, for giving us of your precious time to be here with us today. I have prepared a long introduction of you, but I think you had shortened it quite a bit.
Yes.
So and after my introduction, we will give you a few minutes to please give us a glimpse into who Gehan Gunatilleke really is. You know, away from the madding crowd, as they say.
Let's see.
Okay. So our guest today is Dr. Gehan Gunatilleke, an attorney at law and a founding partner of Lex AG, a law firm based in Colombo. Prior to founding Lex AG, Gehan was an advisor to the Ministry of Foreign Affairs, where he served on the negotiating team on international trade concessions. Gehan currently serves as a commissioner at the Human Rights Commission of Sri Lanka. He's also a non-executive independent director at Janashakti Insurance PLC and a research fellow at Pembroke College, University of Oxford. Dr. Gehan, you have always been in the forefront on various panel discussions, TV talk shows, giving us your views on issues concerning our country. You mostly speak from a legal angle or from a human rights perspective. Thank you so much for all of your insights, which we have certainly been enlightened with and kept us informed and educated. I, for one, enjoy all the programs that you've been on and look forward to what you have to say with us today. Could you please share a little bit about yourself so we get to know Gehan Gunatilleke?
I mean, there's nothing spectacular to share, so I don't know what exactly to say, but I think I'm glad to be here. It's also interesting that, I don't know whether Chris has shared this with you all, the location that you make your protest happens to be on the top of Sunetra Lane, and my childhood home is down that lane. Stag Place is just around the corner. So, you know, when Chris said, why don't you come and speak to the group, I couldn't refuse for more than one reason. I want to get a little bit of a glimpse into my childhood, and that was my neighborhood. Yeah.
Okay, lovely. So it's
somebody from our neighborhood.
Yes,
Yeah.
So nice.
Of course, I've moved since then, but
his family is still there.
My family, my father, all of them are still there. Yeah.
Okay, so they must be used to us on a Sunday evening.
Yeah, I mean, they are used to it.
We've been there for nearly 2 years.
Yeah, no complaints about it. Yeah.
Okay, great. Okay, anything else anybody wants to ask Dr. Gehan about? Where did you school, Dr. Gehan, just if you don't mind me asking?
It was a school that Christopher also is familiar with.
I see.
It's in Magadana. Yeah, we had a Catholic upbringing, St. Joseph's College.
You can see the halo.
Yeah, he didn't really interact with me much when I was in school because I was a Malli and he was a Ayya, and you know that there's always a hierarchy. But after leaving school, he warmed up And after that, we became friends.
Your secret society.
Since we are now going on that, I'll make this very short and we'll make it very quick. No, I have to correct you there. You probably can't remember, but I can. Okay, I have a bad memory. But when we were small, during the primary area at St. Joseph's, we used to play lock and key. That used to be the game for us kids and us friends. So I used to play with all my friends. Somehow, I don't know how, but Gehan Gunatilleke, being 2 or 3 years younger to me, used to also be in that crowd. And I remember very clearly, no one wanted lock and key, one set of people are catching you, one set of people are, trying to hide. So no one wanted to be on the other team as Gehan, because although he was younger to us, he was a fantastic athlete. He could run really fast. So everybody knew that if Gehan was going to be catching you, you're going to get caught, right? So they want to be on Gehan. I remember.
So St. Joseph's has a lot of imports. And even at the grade level, I seem to have been an import for
yes, you were import from a different grade, though.
Yes,
right?
in fairness. Yeah.
Anyway, let's move on. Nice.
It's nice to see that, the insight.
I must add, we're proud to someone like him.
Okay,
at his age, and we are always saying we need to have younger people, newer faces. Right? These politicians who we have, some of them have been 45 years in politics and they still don't want to leave, even though their schools say learn or depart. They don't seem to want to learn or they want to depart. But actually, it's so nice to see younger people. We interviewed Prashant a few weeks ago, and it's lovely to see someone like Prashant Divisa and his movement. So proud to have people like you.
We always want to have you on the show. Dr. Gehan. So let's get the discussion started then. So I have a few questions to get the ball rolling, and then the others here will also have some questions to ask of you. So Gehan, we have seen a number of shut-up laws being passed in Parliament. Why the haste in passing these flawed laws, and why is the government trying to clamp down on free speech?
Yeah, I think it's important to understand the history of media industry in Sri Lanka. So the starting premise in terms of any citizen movement or any even citizen participation in a democracy is that you have to have the channels of speech, channels through which the medium through which you actually interact with government, with institutions, with state. They have to be relatively accessible and free. And it has to also be channels where you can receive information to act on, right? So that is where the media is absolutely important. Without free media, you cannot have free speech, and without free speech, there is no democracy. So if you go back in history, what has happened to Sri Lanka's media? And back in the day, you only had mainstream media and a few alternative media sources. But what happened? Journalists were killed, they were disappeared, they were assaulted, they were beaten up, they were harassed, threatened. Media houses were set on fire. We have had a long history of intimidation and basically destruction of the media industry in Sri Lanka. And this has happened across governments. So it's not even one government's fault. It's a trend across governments, because any government would be resistant to the idea of being held accountable, and free media is so crucial to that. So over this history, when you have your media institutions being under assault in that manner, media institutions have learned, and journalists from mainstream media institutions have learned to self-censor, to play by the rules, not to cross too many lines, not to step on people's toes. Otherwise, you know that the consequences are well known. So if you fast forward to, say, the post-war era, there you don't have as many. I mean, you still had journalists being assaulted, you still had the likes of Prageet Teknaligoda being disappeared, Lasantha being murdered. You still had those, but you'll see the trend where direct violence against media personnel began to drop. It has something to do with how media has become survivalist. And the media institutions have self-censored. So now you look at the media, the mainstream media today, it is a mainstream media landscape that has learned to survive. Otherwise, the consequences are well known. So it's a survivalist media. Right. Now, bearing that in mind, we had the advancement or the evolution of the media landscape where social media started to come up, right? Here, this is a completely chaotic, uncontrollable space. Right? People can say what they like. For the first time, you can criticize someone without much chance of being suppressed. And this is a very scary thing for the state, right?
Sure.
Because with all the effort put into controlling the channel of information over the years, suddenly you have this new medium, social media. You have Facebook, you have Twitter, then eventually things like Instagram and TikTok. These are spaces that cannot be controlled because the levers of power are not in Sri Lanka, they're elsewhere. So you might have, different conversations in places like the US and Europe where people are upset with the amount of control that the tech companies have. But here in Sri Lanka, yes, that is a conversation. But in addition to that conversation, there is this sense suddenly that people can speak without being controlled, right? And then what happened in 2021 and then the lead up to 2022, despite having what I would call a captured mainstream media, and what I mean by captured is essentially mainstream media play by certain rules, and they have to, if not, they will not survive. Despite that captured media, you had this proliferation of protest, humor, dissent, criticism on social media that changed the narrative. Quietly, people began to speak out, and even the strongest government was not able to control that narrative, right? And then you had the remarkable events of 2022 taking place. So I maintain that you couldn't have had 2022 without social media. Okay. Now to answer your question, I think the question has been answered. Why now? Why control social media? Why pass the Online Safety Act? Well, you need to because there is this new space, which is not new anymore, but it's well-used space where people don't follow the rules anymore, aren't subject to control, aren't subject to intimidation and threats because it is a free space and because you can be anonymous, because you have strength in numbers, all of that. So now this new initiative is designed to tell people, look, there's another legal regime and you can face liability and you have to be careful. And if not, there are legal consequences. Now, I can get into the details of the Online Safety Act and the definitions and all of that, and even reassure you that some of those definitions are quite, there's a high threshold to meet those offenses. But that's not the point. The point is that already, by your question itself, it's clear that there is a fear psychosis. And the fear psychosis is the point.
Yeah.
So it's interesting that you don't have to go down the route of burning institutions, threatening people in terms of assault and murder and disappearance. You don't have to go down that route anymore because the tools of repression have become more sophisticated. And now you can threaten legal action. Now you can threaten jail time. Now you can threaten removal of a license or registration, whatever it is. And people are still frightened. So that's really what these laws are about. The response of civil society and anyone who cares about maintaining free speech has to be, I would say, at least twofold. One would be to give clarity to people that this is what the law actually says, this is what you should be careful about, this is what you ought not to be careful about, where you don't have to fear, you don't have to get excited, you don't have to self-censor. And the next thing it would be to keep pressing for reform. Now, the Human Rights Commission, the moment this law was placed on the, the moment it was gazetted, and then eventually placed on the order paper, the Commission issued some observations on the bill and encouraged the government to change certain things about the bill. But one of the things that was highlighted by the Commission was that legal reform is not what we need. It's not the need of the hour. What we really need in Sri Lanka is institutional reform. We really need to be able to trust our law enforcement officials to apply the law, in good faith. When you do that, it doesn't matter what new laws come, because we're not afraid of these laws being abused. So the combination of knowledge that this new law is here and we can face consequences, and this idea that the law enforcement officials may not apply it in good faith because of the track record of other laws, creates a fear psychosis. And that's a long-winded answer, but that is, I would say, the main sort of thrust behind some of these new legal initiatives. Yeah.
Just in time for the upcoming elections.
Well, I don't know if it's just about elections, because I would say that there is a lot of support across the board for the regulation of social media, because it is a space that many people are uncomfortable with, right? So I've heard the narrative that we need this to protect women and children from exploitation and abuse online. The National Child Protection Authority was never really consulted in this process. Ask them whether we need a new law, right? I would love to, engage them directly. And when I have, their answers have been very, very insightful. That, there are gaps in the law, but those gaps can be addressed by addressing the specific law, not this new monstrous, legal regime that you bring in to regulate all of social media. But I think there is discomfort, and therefore there is, out there at least, a lot of people that would be in two minds about regulating social media. They'll say, social media, a lot of defamation, lot of bullying, lot of, pornography, exploitation. We need some kind of regulatory mechanism. But the problem is then you're handing over that regulatory mechanism to institutions that you can't trust. So that for me is the bigger problem. The text of the law is not the problem. It's the institutional capacity and willingness to apply that text in good faith, which is the real problem at the end of the day. Yeah.
And I think they were also quite fearful of another Aragalaya. A lot of people seem to think that that's another reason for some of these laws.
There's certainly some headline comments that can be made in terms of why this law now. But I don't think it is just a response to the Aragalaya. I think there's a broader trajectory here, and there's always been a need to control social media. If you go back to some of the speeches that were made just after the war, it's all online. You can find those speeches by various defense officials. Even the former president made a speech about social media being the new national security threat. Now, this is back in 2009, just after the war. Yeah. So this problem has been anticipated, or quote-unquote problem, it's not a problem for us, it's a problem for those in power, has been anticipated well before the Aragalaya. But I think the Aragalaya was the straw that broke the camel's back in many ways. It just the full force and power of social media was on display, right? And then that would answer your question as to why suddenly such a momentum in terms of the Online Safety Act. And it is also, a little bit of a I would say, scandal when you look at the speed at which the Online Safety Act was passed, and also now the admission that there were gaps in that law? Did it fully comply with the Supreme Court determination? There are all kinds of questions being asked. None of that would have been really a problem had this been a fully meaningful consultative process where the civil society actors were consulted, where the tech companies were consulted, where national bodies like the National Child Protection Authority was consulted, like the Human Rights Commission was consulted. If this was a consultative process, we get a better law. And that's always the case. To take the example of the Right to Information Act, it took a little longer to pass, but it passed with maximum consultation, and we got one of the best laws in the country.
Gehan, interrupt you.
Yeah.
So you're saying that the Human Rights Commission was also not consulted?
Well, I mean, that we became very clear in our observations. We mentioned in our observations that we got our first glance at the observations when it was gazetted. I think it may have been somewhere in September. Because it was placed on the order paper, if I'm not mistaken, on the 3rd of October. So we got our first glance at that point. And it's not to be critical of the entire government on that front, because there are certainly line ministries that are much better, that actually share the drafts in advance and then gives the commission an opportunity to take a look at these specific laws. Now, for example, the Justice Ministry shared the disability rights bill well in advance and gave us an opportunity to have a look at it. The Presidential Secretariat has been sharing certain bills as well. So this happens, but that doesn't take away from the overall criticism that this lawmaking in Sri Lanka has to be more consultative. And even from a technical point of view, you just always get better laws as a result of that. Another example is the data protection law. We have one of the best data protection laws in the region, and that came out of a lot of consultation and careful consideration. Nothing was rushed, and now we're in the process of bringing various parts of that law into operation. So if we adopt that route, we often get better laws. So it's from a technical point of view also it's a worthwhile pursuit. Yeah.
So on the topic of human rights, Gehan, what can someone do if they see a human rights violation, and what are the mechanisms in place?
Okay, that's a bit of an open-ended question, but let me try and, there are various remedies that can be pursued. So it depends on the violation. So if someone, say, notices, assault of someone by a state official, you can complain to the Human Rights Commission. You can file a fundamental rights application before the Supreme Court. It's always good to consult a lawyer and get legal advice on what your options are, because your options often depend on the nature of the incident, right? And sometimes what you might consider a human rights violation may be just an inconvenience to you, and you might have a remedy that ought to be opted for instead of creating another backlog before the Supreme Court. Now the Supreme Court is the apex court in the country. You don't want to be taking the most frivolous cases to the Supreme Court, right? So again, it might be good to always seek some legal advice on what your options are. But to answer your question, it all depends on the type of violation, and I think being conscious of other people's rights as much as your own rights is very important there, because often when you're experiencing a rights violation, you are going through trauma. So you're not always aware of, what remedies do I have? Should I go to court? Should I go? So the community needs to be aware of everyone's rights. And so sometimes you're very aware of your rights when they're not being violated or after they're violated, but you're not always aware of other people's rights. And when you're going through that trauma, a community coming together and helping with, the remedies, the options, getting people in touch with lawyers, getting, the psychosocial support that might be required, all of that is really important. But I think, I answered your question in a very kind of open-ended way, because you might need to give me a concrete case, and I can
ask you, could you share maybe an example with us of, a complaint that has gone through to the HRCSL, and just for the sake of our viewers who are listening in?
I mean, okay, let's take a hypothetical. I can't obviously discuss specific cases, but say, for example, you want to travel to a particular part of the country, right? And you are stopped. You ask the question, okay, why can't I go here? And then you're given the answer. Let's say that particular state officer says, no, you can't go because that place is prohibited, right? Now, as a citizen, everyone has the freedom of movement, and that means you have the right to go anywhere you like. You can't be stopped unless it is some kind of restriction that meets a particular criteria. And that criteria is very clearly laid out in the Constitution. So if you're stopped, that restriction on your freedom of movement has to be a restriction that is by law, and it has to be for a specific public purpose. So it can't be just any law, it has to be a law for a purpose. Because that's what it means to have a fundamental right. It's a very, very important thing. And it can't be restricted except by something equally important. Right? So the first thing to know is that you have the freedom of movement. You have the right to go anywhere you like in this country, and no one can stop you. Unless that restriction is by law and for a particular public purpose. So let's say you're stopped and the reason given to you is you can't go there, national security. That's a valid public purpose, but the person stopping you should be authorized by some kind of legal instrument like a law or an emergency regulation to be able to do that. So if you have a legitimate reason to go to that place, say you're traveling to your workplace, or you want to just see a forest in that area, or you have some legitimate reason, and that place turns out is not regulated by law, there's no prohibition, you have the right to go and file a fundamental rights case or a complaint in the Human Rights Commission, and then there will be an inquiry as to whether the restriction on your fundamental right, which is the freedom of movement, was a legitimate restriction, right? And then if it is not, the Human Rights Commission or the Supreme Court, depending on the forum you pick, may issue either an order or a recommendation, depending on the institution, saying that your fundamental rights have been violated. And then you might get a remedy like compensation. Or that state institution might be given a directive saying, look, you need to send a circular to all your checkpoints saying you can't stop people from traveling. They have the freedom of movement. And if you're stopping someone, you have to have legal authorization by an act of parliament or an emergency regulation. So law doesn't mean also someone picking up the phone and having the authority to do so, saying, I don't let them. So a verbal diktat or some kind of circular doesn't qualify as law. That's how important fundamental rights are. What qualifies as law is only an act of parliament or an emergency regulation. Right, so that's the framework. That's, I can see.
You know what I want to add here?
Christopher smirking.
We had a former president saying,
what?
My word is.
Yeah,
circular.
But we all know how that ended.
Yeah.
Right? So yeah.
That's what I was.
Yeah.
Chris, you have some.
Yeah.
Yeah.
That's basically my answer in terms of illustration. But that could be equally applicable to a range of fundamental rights that we have.
So, Gehan, I've got a few questions to ask you.
Sure.
All right. This is about human rights and repressive laws in Sri Lanka.
Yeah.
The first one is, how does the Human Rights Commission of Sri Lanka address concerns regarding regressive laws that may infringe upon human rights and civil liberties?
Yeah. So the Commission has a mandate that is, I would say, fourfold. The first, and I would say the most important mandate, is to receive complaints from citizens and inquire into those matters and come up with some kind of recommendation if there's a violation. That's the core mandate. And unfortunately, that mandate also takes up an enormous amount of time because there's a massive backlog of cases, right? So like I mentioned, there are cases that are very serious, like someone's freedom of movement being restricted, or even more serious than that, where someone has been tortured, or you find people who have died in custody. So these are very, very serious cases. But then you also have, on the other end of the spectrum, not necessarily flippant, but cases that might be resolved through some administrative intervention. Like you might have people whose electricity meter has been tampered with, and they're coming and making a complaint to the Human Rights Commission. They're absolutely entitled to do so, and we have no choice but to look at every single case. But when you look at it as a system, you are going to have massive strain on that system. We only have a couple of dozen inquiring officers. So if you do the math, an inquiring officer will often have 400, 500 cases that they're dealing with. Right. So now imagine whether that system can so really there's an enormous amount of energy that has to go into that mandate. But apart from that, I would say the second most important mandate, and sometimes even in terms of shaping the legal system, the most important mandate is to advise the government on bills, that is proposed legislation, and laws that are already in existence in terms of their compliance with the fundamental rights chapter of the Constitution and international human rights. So to give a few examples, when the bill to repeal the Prevention of Terrorism Act, the PTA, came in, that was the anti-terrorism bill, we shared our observations and concerns about that bill, particularly on questions of the definition of terrorism, whether this definition will capture certain protests that have nothing to do with terrorism, things like that. Then when the online safety bill came, same, we made some comments. But we have also looked at existing legislation. Now, for example, for a very long time, it has been accepted even in the Supreme Court that we ought not to criminalize the conduct of same-sex couples when it's consensual. Right? That world over, we have recognized that is not a criminal prohibition that we should sustain on our statute books. And now this matter has gone to the Supreme Court also, because there's a private member's bill to repeal that section. And the Supreme Court has also endorsed it. And there's a wonderful determination on that. So now this is the existing law. So the Commission has commented on that and invited the government to adopt that private member's bill as a government bill and go ahead and pass that. Okay. So I would say that mandate is also very important. So when it comes to laws that are problematic in terms of human rights compliance, our mandate is to look at both the proposed laws and the existing laws and try to push the government to consider reforms. Sometimes the reception is positive, and it often depends on the line ministry, depends on the individual actor involved. And sometimes we don't get much of a response, but that's part of the mandate. We have to continue to do that. And we're independent in the sense we're outside government, but we're part of the state machinery. We have to keep making our observations known and keep interacting. It's also absolutely necessary that we maintain fairly good relations with those actors. Otherwise, nothing will get done. So that is part of the mandate as well. Yeah.
I'm going to ask Manpreet, based on what you just said about that law, that private members bill.
Yeah.
Do you see it being? What you suggested. Do you see it happening?
So I don't see any
coming from the government.
Yeah. No, I don't see any impediment to it. From a legal point of view, even from a political point of view, I don't really see an impediment, because if you look at that Supreme Court determination, it's a remarkable determination, because not only does it go into whether this bill is incompatible with the Constitution, it goes into the history of the bill. The fact that this bill, this particular penal provision that's already in existence, the bill is a private member's bill to repeal it. Yeah. So it goes into the history of this penal provision. The fact that it was brought in by the British in the early 20th century to reflect certain norms at the time in Britain, and that there's absolutely nothing prohibiting such activity in the more indigenous culture. So it goes into even Buddhist theology and teaching, saying there's nothing prohibiting it. So I think the fact that the court went to that extent to really show that this is something that can be adopted means that it is a low-hanging fruit and it really needs to be done. I'm not entirely certain that this will be done in an election year because there are so many priorities that might preoccupy a government in an election year. So I don't know. It's difficult for me to predict this. But I could say for certain that there really is no good reason for it not to go ahead. And no one should be able to say that, culturally this is problematic or legally this is problematic. Because those questions have been definitively answered by the Supreme Court.
All right. Yeah. Thank you. Yeah. The next question that we have for you is, can you provide examples of specific regressive laws or policies that the Commission has identified and advocated for reform?
Yeah, so as I said, the Prevention of Terrorism Act is definitely something that needs rapid repeal. It needs to be repealed because the world also has advanced away from this traditional way of arresting people and keeping them in detention for months on end in the hope that some evidence is discovered. Right? You catch and look for the evidence as opposed to arrest people based on evidence. Right?
We have this happening to lawyers, Hejaz Hizbullah.
Yeah. Absolutely. So I think the PTA is right at the top of that. But apart from that, I think the Online Safety Act has been identified as problematic and requiring a lot of changes. The government has recently announced, there was a cabinet decision about it, that some changes will be brought in based on advice that has come from an expert group. Those changes are not public yet, but I imagine, knowing who the experts are, that those amendments will improve the law dramatically.
Good.
If they are adopted.
It's good to hear.
Which is good to know.
Yeah.
So let's see what happens there.
All right.
We have also identified things like the prohibition on same-sex conduct in the penal code. There are various other the matters that need to be addressed, but right at the top of the laws that are problematic is the PTA. But I think I need to say one thing here. We are often preoccupied in trying to fix the text of laws.
Okay.
And I think that's not the right approach. Because fixing text doesn't really get you very far. You have to fix the text, but you have to really fix the institutions. Because there's also an example of the ICCPR Act. I don't know whether you all are familiar with that.
Yes.
So the ICCPR Act has a section 3, which criminalizes incitement to violence. Yeah. Now, what is incitement to violence? That is, if I say something to all of you and I am influential and I'm able to convince you all that you all should go and commit violence against those people, right? That's incitement. I have to have a lot of control over you. And this particular offense criminalizes incitement to violence through the advocacy of hatred against specific groups, national, racial, or religious groups. That's the offense. So you can see there are many elements to the offense. Now, if I say something offensive that upsets you because you're, say, from a particular religion, or upsets her because she's from a particular religion, that may be deeply offensive. That may be a wrong thing to do. That may be immoral and worthy of criticism, but it's not incitement, right? I'm not inciting anyone. I might anger you, but incitement means I'm convincing you to go and attack someone else.
That's right.
So this law is actually modeled on the international standard. There's nothing wrong with the text, right? It's word for word the best, word for word the best standard you can get there. But it's been routinely applied to criminalize blasphemy, where someone says something that is offensive about someone's religion, right? So the problem is not the text, the problem is the institution. And in fact, again, the Supreme Court recently, in a case concerning this social media activist, Ramzi Razik, right? another fantastic judgment that goes into this matter and says, look, this offence is a complicated offence. There are many elements to it. You can't apply this law the way you feel like applying it. You have to actually apply it according to the text. But the broader political problem here is that it doesn't actually happen in practice, because the institutions that are tasked with interpreting the law and applying it have to, understand how the law is to be interpreted and applied, and also have the good faith to know a case where even if the complainant is powerful and sometimes a religious actor will be the complainant, despite that power, we have to apply the law to that text and not in a way that others would like us to apply. That we're not there yet. So this amendment of the Online Safety Act shouldn't necessarily be celebrated, because we're still reliant on institutions to implement the act. And if you can't trust those institutions, then the act can be implemented in any way. We can't even predict how it will be implemented. So that's a problem.
Yeah, and especially Dr. Gehan, I want to, you are now on point to say that, the implementation part, you can have all the correct laws and all the correct texts, and if some idiot wants to abuse his power and misinterpret a law, then there's a big problem. And we are this is a question to you. How effective can HRCSL be when the IGP in place has been convicted of torture in a fundamental rights case, further has been alleged to have been negligent in the Easter Sunday attacks? How can this apparatus, this institution of police and law enforcement come through when it's led by someone who is, right round faulted?
So I have to clarify, the Human Rights Commission doesn't rely on the police for enforcement, right? So that's the first thing to note. If we don't have an enforcement arm that requires reliance on the police. So our relationship with the police is very different. Our relationship with the police is where if someone complains against the police will be a respondent in that case, and we might issue a recommendation against the police. Or if there is some matter that requires training on human rights, if, for example, the police needs a lot of training on how Section 3 of the ICCPR Act needs to be interpreted. So the Human Rights Commission might step in and work closely with the National Police Academy to do that training. But there is no mandate overlap in terms of enforcement. So whoever the IGP is, it doesn't affect the Human Rights Commission in terms of its ability to do its mandate or fulfill its mandate. If you're asking a question about the protection of citizens from crime and all of that, I'm not the best person to ask that, because I'm not an expert on crime fighting, right? There is certainly a question mark about fundamental rights being violated and what consequences should flow from that violation. So there's no conviction here, by the way. It's a finding by the Supreme Court that someone's fundamental right to be free from torture was violated, and XYZ police officers were held responsible. Very different to a conviction and someone being found guilty, because there's a separate torture act for that, right? So if someone who has been found responsible from the Supreme Court or by the Supreme Court is then prosecuted under the Torture Act, then there could be a conviction. So the situation is actually not even close to conviction, because the Attorney General's department will have to initiate a prosecution, right? So what has the Human Rights Commission done about the general impunity that we see when there's a Supreme Court decision naming certain officers that are responsible for, say, someone's death in custody or the torture of an individual? when the Supreme Court says that you are responsible for the death of, there was a case recently where several officers from one police station were found responsible for the death of an individual. I was, in fact, when I started my law practice, that was one of the first cases I was involved in. So then now there is this finding. The next step is for there to be a prosecution, right? So then again, if the Supreme Court finds that someone is responsible for torture, the next step is for there to be a prosecution. So what the Human Rights Commission did was it noted some of these key cases and wrote to the Attorney General, and that letter is in the public domain. We said you must prosecute, right? So that's all we can do, because we don't prosecute, we don't take the step to actually convict anyone. There is a process, and the department has to look at the evidence, and if there is strong evidence that there could be a criminal offense committed, they will have to take those steps. So that, I think your question is a good question, but it's complicated because there are different institutions involved at different levels, and there is not quite a conviction here. There is a pronouncement about responsibility which is very different to a conviction. Yeah.
Now the question for you is, how does the Commission collaborate with government bodies and civil society organizations to promote legislative changes aimed at upholding human rights standards while ensuring law and order?
Yeah, that's a great question. So we have also been thinking about this, try and strengthen the way we interact with government institutions and civil society, because as a sort of independent institution, we can actually play the role of an interlocutor, where we can not only interact with these various actors, we can also form the forum where those actors can interact with each other as well, right? So one of the things that the Commission used to do in the past is have these thematic subcommittees which involve the participation of both commissioners and members of civil society in one forum to discuss certain human rights issues. So that can be gender, that can be child rights, it can be rights of persons with disabilities, various issues. So we have decided to relaunch that. So we're thinking of 8 themes and inviting people to nominate members to these committees. And there'll be at least one commissioner and maybe a few other staff members of the commission participating in that committee alongside civil society members. And then we'll also invite certain key state institutions to that membership as well. Now, for example, on the rights of the child, I'm pretty sure we'll invite the National Child Protection Authority, because that's a key institution. And then that might be a good forum to discuss these issues and also propose certain reforms, identify issues that need attention. There may be a variety of benefits that flow from such a mechanism. It's not a new idea. It's just that system has fallen into disuse, and we're resuscitating it in the hope that this will sort of propel people to come and discuss issues, and then we might find some practical solutions with those state institutions as well. So the themes that we're thinking of include freedom of expression, right? So because we've identified freedom of expression as such an important issue in this current context, there will be a subcommittee on freedom of expression as well, and hopefully there'll be some good participation in that. Yeah.
Thank you. I have another question for you. What measures does the Commission take to monitor and evaluate the impact of existing laws on the protection of human rights and maintenance and law and order in Sri Lanka?
Yeah, I mean, that's a similar question to Christopher's question. I think what we do is we monitor the Gazette and the order paper of Parliament, and if there are new laws that are in the pipeline, we will be identifying that and providing observations. But even before that, before the proposal comes to that stage, the hope is that we will have a constructive relationship with the line ministry, where a line ministry will send the draft in advance, and we are able to influence the draft in some way before it's even placed on the order paper or gazetted. Sometimes you'll have civil society activists who are working closely with government actors. They are in the know, and they will sometimes alert the commission to request the draft in advance. Now, for example, there's a new law that is being considered to regulate non-governmental organizations, right? NGOs, and that draft is being prepared. And so, because we were alerted by our civil society network to try and, because they also had got a copy of the law, we made a request to get a copy of the law so we can also have a look at it and share our observations. Yeah. So that will be so it's formal sort of monitoring of the Gazette and order paper, but also the informal network that might share.
Does these government institutions really cooperate with you all, with the human rights?
I must say it's mixed, because sometimes there's excellent cooperation. So it's wrong for me to say no, they don't cooperate. Sometimes there's excellent cooperation. Sometimes there are gaps in cooperation. It's all very, very personality driven, and I think the role of the commission is not to take a stance where we are not we are better than everyone else and everyone should cooperate with us. We have to build those relationships as well, because these are human beings, and human beings need a little bit of coaxing and all of that. So I think we're taking that soft approach, and we have had success with some institutions for sure.
Can I jump in there? Because it's a related question. So I would like to ask, what exactly is your scope? Because you said you are, in a sense, outside the government, but also working within the framework.
Within the framework of the state.
Of the state.
But not within government. So we're not a government institution. So we're not a department. We're not a corporation. We can raise our own funds. So there are certain institutions that are named in the constitution that are considered independent. So that will be the Human Rights Commission, that will be the Right to Information Commission, the National Police Commission. There are a few institutions, and people who serve on that are not government servants. Correct. Right? They will have their day job. Right? So I'm a corporate lawyer by day, or let's say by afternoon. So we don't really feature in the government machinery, but still we're very much part of the state machinery, because we get our funds from the consolidated fund in addition to whatever other funds we raise. So we may even have public officials being seconded to us, particularly in matters of administration and finance. So it's a little complicated. I think the best way to describe us is a statutory institution within the state machinery, but independent of government.
Independent of government. Okay, so my next question is in terms of, say, for example, when the Human Rights Commissioner or someone in Geneva, for example, talks about the violations of human rights in Sri Lanka, and then our government fairly promptly issues a denial saying, no, that's not the case or whatever, then what is your position there? Because obviously you know what's happening, right? So I understand the role of the foreign ministry as well. The role of the foreign ministry is to engage in diplomacy, and engaging in diplomacy often means that you have to defend your government and spin whatever happens, and that's your job, right? The role of the Human Rights Commission is not that. The role of the Human Rights Commission is to provide objective picture of the situation on the ground. So when it comes to international fora, we issue certain reports which are kind of shadow reports or parallel reports to the government report, right? And this happens on a number of fronts. Now, for example, the latest report like that was on the rights of persons with disabilities. Okay. So the state party will send its report to that relevant UN committee that oversees implementation of the convention, and we will send a parallel report, right? That is basically a commentary on the state report, right? And I mean, in the past, very famously, the Human Rights Commission, I think in 2017, issued a parallel report on the state on torture in the country,
which got a lot of traction and coverage because this was so while the government had a particular report on for that particular committee, the Committee Against Torture, the separate report from the commission was considered to be a sort of objective assessment on the situation, because basically it said these are the number of complaints we're getting, right? And that's a strong indicator of the situation in the country.
Yeah,
Exactly.
just want to jump into that section of torture. Now we know you told about this conviction and the definition of the conviction and the Supreme Court determination on that matter. I just want to ask from you, with regards to the Torture Act, I think 1994 Act, yes, Torture Act, Section 2(1) or something, I can remember. How many persons have been, officers do you have any idea of a number of people who have been convicted, like at least charged after the conviction of torture?
So I'll tell you a story instead of answering the question directly, because I can't tell you the exact statistic. Sometime, I was following this very closely about 2 or 3 years ago. The number of convictions was something like 4 or 5. It was very low, but I know that there were some successful convictions a little later. So maybe 5-10 years ago it was very low, but more recently there have been some successful convictions. I just don't know the number off the top of my head. But I'll tell you a story as to why this is a tricky area. You see, the threshold to get a fundamental rights judgment in your favor is a lower threshold, in the sense that you have to prove your case on a balance of probabilities. It's not the same threshold as a criminal matter where you have to prove your case beyond reasonable doubt, right? So those different standards of proof means that the Supreme Court can look at evidence and give a sort of judgment against the perpetrators, asking them to pay compensation and finding them responsible. So there was a case concerning a person by the name of Gerard, I think it was Pereira, if I'm not mistaken. And he was wrongly taken into custody by the police, tortured, and I think his injuries were so severe that he may have even been blinded but it's a fairly famous case. He went to Supreme Court and he won his case. Right? Now we've mentioned this Gerard Pereira's case in our letter to the AG as well, because there's a big concern here. He won his case and he was entitled to compensation. Now the moment he won his case, essentially what it means is that the Supreme Court of the country has found these officers responsible for torture. Now notice I'm not using the word guilty, I'm saying responsible, because these are two different things. So what did the AG do? The AG took that file and started a prosecution, right, of those officers. Now who is the main witness in this case? The main witness is Gerard, right? So when the High Court case began and the trial began, he was up for his date for giving his testimony was coming up. Got into the bus and was shot dead, killed, right, by assassin, turned out hired by people who really didn't want that case to go forward. So now you would imagine people knowing that story, whether there will be confidence in wanting to take that next step, right? So we have to fix institutions. That's why I keep saying it's not just about law. You can have the best laws. And now the Torture Act is one of the best laws in the sense that there are a few gaps here and there, but it's modeled on the Convention Against Torture, right? So there's no real gap in terms of criminalizing torture. But despite the Supreme Court having that finding, that was the fate of that particular victim. So you need to really ensure that people can be protected by the strong witness and victim protection authority. Now it's been instituted. They empower that institution to ensure that people can take the next step, and be protected from reprisals. Otherwise, you're going to have this kind of case repeated.
Very important question onto that, because now I don't know whether it is possible. I heard of an incident where the person, the victim of that specific crime had actually fled the country for his and safety. And they had been, they are saying that they are going to come through Zoom or some electronic means to the courts and testify. Yeah. I mean, is that possible?
Under our evidence, sort of, let's say, system, and particularly under the Witness and Victim Protection Act, that is possible, right? Because you have those options now, because there will be situations in which there is a real risk to the witness or the victim, right? So that law being passed was very important, because now you have a machinery that can provide that protection. But it's not enough to have that law. You have to resource that institution, you have to empower it, and then you have to put it into practice, and there has to be a culture created where people who are, the key witnesses in these cases are actually protected. And in a situation where we have had a history of people being bumped off because they might be key witnesses, that you're never going to have a system that succeeds in securing prosecutions. Having said that, I have to clarify that we have had more prosecutions, successful prosecutions recently than we have had in a long time. So between 1994 and say 2015, we had a handful of successful prosecutions. Then there has been some improvement, right? So let's see whether that trend continues.
Rishi, you had another question?
Yes. Can I switch tracks and ask you a question related to the Constitution?
Sure.
Is that okay? So this is actually from one of our regulars who couldn't be here today. And her question is an interesting one. If you could change 3 things in the Constitution, what would they be?
Okay, I would change the Constitution totally. That's not just 3 things. Now I have to clarify that I'm taking my hat off as a Human Rights Commissioner, because I don't think the Human Rights Commission has any mandate to comment on the Constitution, but I'll comment as just a lawyer. I would say right at the top of the list should be the abolition of the executive presidency. Right? There's no doubt about it. It's been a long campaign by the people and various politicians. I mean, all the political parties have at one point or the other agreed that this has to happen. And I would say there is no perfect time for it to happen. Unfortunately, sometimes it will happen in the most inopportune moments also. And I think, thinking of the long-term trajectory of the country, that if that opportunity presents itself, it has to be seized. It has to be seized. That's where I would stand. But of course, it might be very, very dicey if it is done for political reasons, right? So it has to come along, it has to come with a package. It can't be just the abolition of the executive presidency. It has to come alongside, commitments to have an election, a general election. But I think that would be the number one thing. The second thing, it's remarkable how we have, and now I can put my Human Rights Commission hat back on. It's remarkable how we haven't had a very robust conversation about socio-economic rights being recognized in the Constitution, despite the fact that we have just gone through the most horrific economic crisis. Why aren't people demanding, and why aren't there more discourse? Why isn't there more of a discourse around the fact that now we have gone through this horrible crisis? It's been fundamentally socio-economic. Why don't we have the right to food, the right to education, the right to healthcare, the right to housing in our constitution? Many countries have already got that. And the fact that we are asking for this sort of economic reforms, and we're trying to change the way we ensure these things for our people and our children in the future, doesn't sort of approach it from a rights perspective, is very curious. So I would certainly include socio-economic rights in the constitution as a major change. The third one, and I'll take my hat off again, is that I don't think any. I think the commitment to secularism in the constitution should be unwavering. It should be non-negotiable. I think that's a very difficult one, which is why I put it at 3, and that probably has the least sort of legs in terms of reform. But religion really should not play a significant role in our governance structure. All religious traditions should be treated equally, and they should be valued equally. And I think, if I really was to comment on it from a sort of Buddhist perspective, that is compatible with Buddhism itself, right? So I think if we really want to foster and promote Buddhism, that would be a feature of our constitution. So I would say that those are the 3 things that I would.
Thank you. That's great. Thank you.
One more question has just come in. You alluded to this before about HRCSL being independent, but how independent is it from the government?
It is as independent as I might be still sitting here talking to you. I mean, clearly it has to be independent. I mean, I must say we have not encountered any interference or any kind of indication that our independence will be taken away. And as long as that's the case, you'll see the commissioners operating the way they do. That could change, but I mean, I can only speak of my experience. On paper, it is certainly independent. In practice, it appears to be independent, and we'll see how it goes.
No, I want to ask you about this. Now, this protest, is it really, we have the right to protest in this country?
Yes.
Why is that now, even today, there was a protest at Maradana, Peta. I mean, police come and tear gas and all that. These things are happening all the time.
Yeah. I mean, let's go back to the example I took about the freedom of movement. The first thing to recognize is we have the freedom or the right to peaceful assembly, right? And that is essentially the right to protest. It's framed as peaceful assembly, which means that if it is a violent protest, you don't have that right. So automatically, any non-peaceful assembly is excluded from your right. Now, once you have the right to peaceful assembly, that means you can go and protest somewhere peacefully. But that right is not an absolute right. It's a right that can be subject to restrictions. So those restrictions have to be by law, and they have to be for a particular purpose. So, for example, a peaceful assembly can be restricted by virtue of a court order that flows from some kind of law, say the police ordinance or the criminal procedure code. The magistrate can issue a court order and say, in this particular location, you can't hold a protest, or you can hold a protest, but these are the conditions, right? So that would be a legal restriction. But then, in addition to being a legal restriction, it also has to be for a particular purpose. So it can't be just because government doesn't like the protesters. It has to be for, say, public order. So the public order would include things like ensuring that traffic moves smoothly, or say it could be public health. Say if you protest today and you are, from the medical profession, there could be a public health crisis. So we are restricting your right to protest. So it's always a balancing act, and often people aren't happy with it. But that's the nature of rights and restrictions. There will be a balancing act. Now, what happened today? I mean, we're still looking at the specifics. If the protest was violent in any way, then automatically you're falling outside the scope of the fundamental right to peaceful assembly. If the protest is peaceful and the restriction is valid according to law, and there was a good reason and a court order had been issued, etc., then it might be a valid restriction on that freedom of peaceful assembly. If the restriction didn't fall within that criteria I mentioned, then it's an invalid restriction, and then whatever complaint is filed in whatever institution, say the Supreme Court will have to go into it. And then the outcome of that could be that the arrests were illegal or the restriction of that protest was illegal. So various remedies can flow from that. But as I said, you have to go through the facts and come to the conclusion that it was an unlawful restriction on a peaceful protest, right? So all kinds of things will matter in that analysis. Now, quite apart from that, people are also arrested. So you have to be arrested in a manner that protects and respects your freedom from, say, torture or cruel, inhuman and degrading treatment. And the thing about the freedom from torture is that there cannot be any restrictions on that freedom. It's an absolute freedom, right? Under no circumstances can you be tortured. Under no circumstances can you be treated, in a cruel, inhuman, degrading manner. So now in the course of arrest, if someone had been treated that way, that would be a violation as well, regardless of whether it was a peaceful protest or a violent protest or whatever. It's an absolute right. So there are many aspects to this that will have to be looked into before someone can conclusively say this is the outcome of this is what actually happened.
And is our police force told about all these things? Do they know? Because the OIC of the Kolpiti, the traffic OIC, told me when we stand on the side there holding a board that I'm doing something illegal. So
It depends on where you're standing. It depends on whether there's a court order against it. It depends on a number of factors, right? So I'm sure you would have had lawyers on this show before, and they would have probably told you that under our law, you are not required to get permission to stage a protest, but you are required to give notice, right?
No,
so
there is no requirement.
well, there is a requirement to give notice. You have to give notice of a assembly.
No. It's about processions. Notice of a procession.
Yes. So if there is if you're having an assembly and you're moving in any direction.
I have studied the Supreme Court rulings, and accordingly, it's about if you don't need a permission, you just need to inform.
That's exactly what I'm saying.
No, let's give
exactly what I'm
give some
saying.
context. No, she's referring to a protest that like we have here at Liberty, where they are stationed again.
Yeah.
They're at the roundabout on the pavement.
So
2 years we've been doing.
Yeah. So the requirement, like you said, so notice is about informing. It's not permission.
Yeah.
Right? It's not permission. These are two different things. The law requires you to only inform. It doesn't require you to get permission. Now, no one can tell you that when you're staging a protest or moving in a procession or whatever, no one can tell you that it's illegal because you didn't get permission. That's correct. But at the end of the day, I'm sure other lawyers would have also said this. There is often a confusion between informing and seeking permission. And there needs to be a lot of work done to make sure that all law enforcement officials understand the difference. I have seen even submissions made in court where those two things are confused, and argument is made that these people had a protest without permission, without getting prior permission.
The Supreme Court was very clear in one of the Supreme Court rulings. It said that it says you don't need permission, you need to inform. But that just because you don't inform does not mean the police can come and disperse it if there is no breach of peace. If there is a breach of peace only, they can disperse it according to the police ordinance.
As I said before, your fundamental right is with respect to peaceful assembly. So if you break that, then you lose your sort of ability to claim a fundamental right.
Well, the question is coming from our two audience members who are seated here, and it's about the latest proposed change to the penal code about the age of consent.
Yes, yeah.
The proposal to bring it down to 14 for the girl child. So the question is, what are your thoughts on that?
Okay, so I think there's a little confusion as to what exactly is being proposed.
Okay.
The Penal Code amendment says very clearly that the age of consent is 16, right? Not 14, not 15, 16. That is the current law, and that's not going to change, right? The age of consent for sexual relations will remain as 16. That's as far as the amendment bill is concerned. I don't know whether it will change it at some point, but I mean, when I looked at the bill, very clearly it is going to be 16. Now, apart from that, once you convict someone for engaging in sexual relations with someone below the age of 16, the court is given some discretion in sentencing, right? In certain circumstances. So let's look at the current law. The current law says that if the offender is under 18, now we are already in the territory of a conviction, right? So age of consent is 16. If the offender is under the age of 18, that means the offender is a child.
Right.
And of course, the victim will be under the age of 16, because if we're talking about this statutory rape kind of situation, then the court can consider the age of the offender if the court kind of establishes that this relationship was consensual. So you're thinking of a very specific situation. You're talking about a boy who is 17 and a girl who's 15 who might be in a relationship, and for whatever reason the boy is now being prosecuted, maybe because the parents were upset or something, and now the boy has to be convicted. The court can give a more lenient sentence if the court is satisfied that the relationship was consensual, right? Now, that's the law at the moment. What the bill is proposing to do is to put another threshold where you say it has to, the girl has to be above the age of 14 for the court to even consider that. So it's rather confusing.
To give the consent even, she has to be above 14.
Exactly.
14 and above.
You see, so yes, there is 14 is connected to consent, but right now it's 12. So it's taking 12 to 14. Right now, according to the Penal Code, Section 83, you can't give consent unless you're 12. And then yes, I'll come to the complication. But for sexual relations, you have to be 16. Okay. So someone between the age of 12 and 16, the court can consider certain circumstances and conclude, okay, the boy is under 17 and this girl seems to be in a relationship with the boy, so therefore we can give a lenient sentence. Because the conviction is based on the fact that the girl is under 16.
Yeah.
So anyone above the age of 12 and below the age of 16, the court can consider it, right? So what the bill is doing is it's saying, no, not 12, not 13, you have to be 14, right? And so that's where the 14 comes in, for the court to consider. But here's what's problematic. The problematic part is not with respect to the 14 so much. I think still 14 is too young, and maybe 15 is better. The age at which the offender gets this leniency has been increased to 22. So then now we're talking about adults, not children. That's the part that needs to be looked at very carefully.
22, that's...
Yeah. So now we're talking about a 22-year-old and a 14-year-old. Oh, sorry, maybe a 21-year-old and a 14-year-old. That may be something that needs to be looked at. So it's a very complicated amendment.
It's a very serious thing. 22.
But
I mean, I feel that, it's trying to give leniency to pedophiles.
Well, it's a jump from 18 to 22, no?
the jump from 18 to 22 is the problematic part of this.
Definitely.
Not so much the jump from 12 to 14. I think ideally you would jump from 12 to 15.
The age of consent for marriage?
18.
18. Your consent for marriage is 18.
18.
So it's like a...
That's the general consent, or there are exceptions. Under the Muslim law, it could be 12 with the wali's consent, and below that also you might have the qazi coming in. So there's no concrete age of consent when it comes to the Muslim law, but the general law, it's 18.
So we're going to end today with quotes of the week that our friend from GGY, Lisha, is usually in charge of. She's unable to be here today, but she has sent in her quotes. And she's found quotes today that are from two very well-known figures. The first one is by world icon Mother Teresa, who says, "Human rights are not a privilege conferred by government. They are every human being's entitlement by virtue of his humanity." Very, very relatable to today's topic. And the other one is by Martin Luther King. "Commit yourself to the noble struggle for human rights. You will make a greater person of yourself, a greater nation of your country, and a finer world to live in." Wonderful quotes, Lisha, as always. Thank you so much for doing that for us. So I think, let me take this opportunity then to thank Dr. Gehan Gunatilleke for sharing with us this evening, sharing your views, your concerns. To the GGY gang who is here, and to CK back there, thank you very much for your support. Thank you for an excellent discussion, everybody, on day 265. So a reminder that this Sunday we will be at our usual street corner at Timrigasaya for day 266. And tomorrow we will be at Liberty Circle at 5 o'clock. Please join us there as well. Come out and support. And that's a wrap from day 265 from GGY. Thank you for tuning in, and good night, everybody.